Yes, so I'm going to talk about the decision-making process, and many of the things that I will discuss here, of course, have been kind of touched upon already, but I wanted to kind of give you a little bit of context of why we do have the decision-making process, how does it work, who is taking the decision, etc. So I think it's always good to start with the question, why do we have this mechanism in place? And as has been mentioned already, the main principle of the EEA agreement is the principle of homogeneity. The whole idea is that we have across the EEA the same rules, and these rules are uniformly interpreted and applied. But homogeneity has many different dimensions. We will talk about the EFTA court and the judicial dimension, the ESA and the surveillance dimension. All of that kind of serves the objective homogeneity. But there is also what I like to refer to as the dynamic dimension, making sure that we take on new rules that belong into the EEA agreement, and this stems from Article 102 EEE. And the main objective is to make sure that the EEA follows all the developments in the internal market, where the EU is constantly developing its internal market laws, its internal market legislation, and that needs to be taken on board into the EEA agreement. And that leaves us to kind of to explore a little bit what does that entail? What do we mean when we're talking about incorporating or evolving the agreement? And there's a very important concept that we are always kind of discussing in this context, and that is the notion of EEA relevance. The EEA unites the 3 EFTA states and the EU into an internal market, which is based on the so-called the 4 freedoms: free movement of goods, services, capitals, and persons. And the EEA is very much focused on this internal market. So outside of the EU are policies. Outside of the EEA are the EU policies then in other areas such as agriculture, the common trade policy, common fisheries policy, etc. The EEA is only about the internal market, and only EU legislation that falls under the scope of the EEA agreement should be incorporated. And this is the notion of EEA relevance. And like I mentioned, it kind of mirrors the internal market to a very high degree, but not perfectly. There can be sometimes questions on the margins, what is really EEA relevant, and that is something that we need to kind of discuss when we are assessing when legislation, EU legislation, should be made part of the agreement. Is it EEA relevant? Not going to go deep into that, but like I was just mentioned, we have a workshop that we in the afternoon that we will dwell a little bit deeper on what EEA relevance means. So I've kind of explained why we have this institutional setup, why we are always evolving the agreement, what actually entails. But then the question, who are the ones that take the decision? And it is the EEA Joint Committee that is empowered under the agreement to take new EU legal acts and make them part of the agreement. The EEA Joint Committee brings together the EFTA states and the EU. The EU is represented by the General Secretariat of the Commission. And like I mentioned, under Article 98 of the agreement, it is empowered to adopt decisions, thereby including new legal acts into the agreement. The Joint Committee always takes decision by consensus. So there has to be agreement by the EFTA side and the EU side before the EU takes decision. And within the Joint Committee, the EFTA states speak with one voice. And of course, that requires coordination within among the EFTA states. And we have a whole structure that is designed to help us to achieve that consensus. So we can can coordinate and consult, So when we meet in the joint committee, we have we are able to speak with one voice. And this structure entails 5 subcommittees that are under the it entails a standing committee, which kind of is the entrusted with coordinating the position of the EFTA states. Under the standing committee, we have 5 subcommittees, and we actually have also 5 subcommittees under the joint committee. And then we also have EFTA working groups and expert groups where most of the actual legwork is being done. So this is the who takes the decision, but before any decision can be taken, we have to go through kind of elaborate process. And the first step really is when EU law is being prepared, is being discussed, being made. There we have under the agreement a right to kind of get our views across. Our experts have right to participate in certain commission working groups, comitology committees. So we have the kind of access to deliberations on the commission side, and we can kind of let our voice be heard. There are also other ways to make the EFTA states which is a very important part of that is the EEA EFTA Commons. But it's very important that the incorporation does already starts when the new EU legislation is being formed. When, however, the EU has formally adopted a new legislation, we can kind of start the formal incorporation process. The first step there is to have an assessment of the acts. And the Secretariat makes a preliminary assessment of the acts, and there are 3 key questions that the Secretariat has to answer. First of all, is the act EEA relevant? And I mentioned what that means. Sorry. The second is, are there any so-called horizontal challenges related to that? And horizontal challenges can relate to the institutional setup of the agreement, the so-called 2-pillar structure, whether there are provisions in the act that relates to relations with third countries, because the agreement only regulates the relationship between the EU member states and the EFTA states. Other references to legal acts that are kind of not part of the EEA, etc. The third then assessment of this is very much linked to the second issue is whether there are needs for adaptations to the act. And adaptations are basically provisions in the decision of the EEA committee that adjusts and kind of regulates how EU rules should apply when they are part of the EU agreement. After the Secretariat has done this preliminary assessment, the EFTA states need to do their own assessment. They need to kind of verify, do they agree with the preliminary assessment of the Secretariat relating to very much the same 3 basic questions that I was mentioning: relevance, horizontal challenges, need for adaptations. But it's also very important that at this stage the member states themselves assess whether there is any particular need for adaptation that relate to that specific country. When that assessment is done, we can start to draft the decisions of the EEA committee. That drafting is mainly done in the Secretariat. Then when the Secretariat has drafted the decision, we send them to approval to the EFTA states, and that is usually done in the working groups and then in the subcommittees that I mentioned. If there is a so-called fast track, which is kind of applies to legal acts that are fairly straightforward and don't need any adaptations and don't raise any horizontal issues and fall into certain sectors, then actually the drafting can start earlier and can only go straight to the subcommittee. But once we have approval from the EFTA state, we send the draft formally to the EU side, which then launches so-called inter-service consultations, that is consultations between the different DGs within the Commission and the Commission Legal Service. The decision is then ready to be adopted in the EEA Joint Committee once they have concluded their own consultations, and this is done by we prepare in the Secretariat a list of all the acts that we think are ready for adoption. We consult with our member state to check if they kind of agree, if they have concluded their procedures for that. Then we send it over to the Commission that does kind of a check on their own, and then we are ready to adopt those decisions at the next meeting of the Joint Committee. The Joint Committee meets usually 8 times per year, and one important kind of thing to mention is that the Joint Committee also, the EFTA states have the right under the agreement to make so-called constitutional requirements to decisions, and in that case, that decision will not enter into force until the such constitutional requirements might be lifted. This really relates to acts that require legislative changes or amendments in the EFTA states concerned. So they need to go through parliamentary procedure to get that approved before they can lift the constitutional requirements. Now, I'm kind of explaining the process, and this is kind of how it works, but of course, when there are kind of acts that require substantive adaptation, there is a need to have negotiations with the EU side. So there can be kind of consultations before we formally hand over, or there might be a need if there are comments from the Commission after we sent it over to kind of relaunch the process. Should they have comments or questions to the adaptations that are proposed on the outside. And I should also mention that while in most cases it's the Commission that kind of process these acts, in some cases they actually also need to consult the Council, and that relates to acts where we have adaptations that are more than just technical in nature. These can be adaptations that relate to the institutional framework, like I mentioned, or also if there are acts that have any financial implication from the EU, and that has to do with all program, all decisions related to program participation. But this is these are the kind of the steps that we have to go through before the Joint Committee is ready to take a decision incorporating a new legal act and making part of the agreement. Finally, I wanted to kind of mention to you where you can find legal acts and when you find them, kind of how to read them, what needs to be consulted. Basically, when the decision, whether the Joint Committee takes a decision to include a new legal act, it simply adds a reference. This is basically a provision in the decision of the Joint Committee, adding a reference to the relevant act in the relevant annexes of the agreement. And there are 22 annexes to the agreement, but also there can also be references to in some of the protocols to the agreement. But when you are applying the act in the context of the EU, you have to read the act in the view of the adjustments that are made to them by virtue of the provisions of the EU agreement. And these adjustments are referred to as adaptations, as I mentioned already, and we kind of categorize them into 3 different categories. There are horizontal adaptations, and those are found in Protocol 1 to the agreement, and they apply to all legal acts. There are so-called sectoral adaptations, and they relate to policy fields and are found in the separate annexes of the agreement. And then there are so-called specific adaptations, and they only relate to specific legal acts. Now, this is a very kind of very quick short overview of all of this. We have a lot of resources to where you can find more information about the things that I mentioned. We have a really powerful tool on our website, which is called ELX, where you can look at any legal acts and just check where it is in the process, incorporation process within the in this process that I've been outlining. We have a web tool that kind of explains in more detail how EEA law becomes a EU law. We have a video there that explains what I've been talking kind of visually, but also a lot of kind of more information about the procedures in individual EFTA states, etc. And then we have also a fairly new material on our website, which explain how to read EU acts incorporated into the agreement. And it explains how these adaptations that I've been explaining, how they really work and how to find them, and how legal acts should be read in the view of these adaptations. I will leave it at that. Thank you.